Hello, and welcome to our presentation on how you can stop foreclosure and save and keep your home. You're about to be introduced to the process of foreclosure legal defense and the reasons why. For many people, this option is proving far more successful and beneficial than the traditional foreclosure options that people utilize. The foreclosure legal defense process works whether you live in your home and want to stay there, or even if you have an investment or rental home that's not proving to be much of an investment anymore. This video presentation is designed to give you an overview of what foreclosure legal defense is and how and why it works. You can find additional information on our website at www.ForeclosureLegalDefense.com. But first, a necessary disclaimer. The information presented in this presentation is for informational and educational purposes only. While the information presented is believed to be accurate, no guarantee is made of its accuracy. You are encouraged to conduct your own research. Nothing in this presentation is to be construed as the giving or offering of legal advice or legal opinion. There's a difference between legal information and legal advice or legal opinion. For legal advice or legal opinion, please consult with a qualified and licensed attorney in your state. Before we get into the process of foreclosure legal defense, let's talk about what's happened to the value of real estate these last few years. This has a lot to do with why so many people are in trouble with foreclosure today. Not only have they perhaps lost a job or had their income cut significantly, the one investment that they thought they could count on that would always hold value, their home, has instead dropped dramatically in value. Now, instead of having equity in their homes, they have negative equity. They owe far more on their homes than their homes are worth, meaning they're stuck trying to pay on a mortgage that doesn't make economic sense. For example, let's say you bought or refinanced your home in 2007 for $300,000. Well, as you know, the values dropped in 2008. They continued to drop in 2009, dropped even further in 2010, and they've continued to drop even in 2011. Here we are at the end of 2011, and now perhaps your home is worth maybe $150,000 or less, but you're still paying on a $300,000 mortgage. And that doesn't make economic sense. You wouldn't go buy your home today if it's worth $150,000. You wouldn't pay $300,000 for it. So why should you have to pay a $300,000 mortgage on a $150,000 home? Now, the interesting thing is, of course, is that real estate values are continuing to fall. A lot of experts are predicting another 20% further drop in real estate values within the next 12 to 18 months. Let's talk about the primary objective of foreclosure legal defense. It's to keep you in your home. Without fear of foreclosure, without fear of eviction, and without fear of having to move and rent another place. In addition to that, we have some secondary objectives. Could you stay in your home? And we're talking about long-term here. Could you stay in your home if the principal balance of your mortgage was reduced to at or below the actual market value of your property, and the interest rate on your mortgage was reduced to between 2 and 4%, and all of your unpaid mortgage payments and taxes were waived, and you are not responsible for any deficiency judgment or 1099. Well, of course you could, because now you would have a mortgage that makes economic sense. And that's the goal, and that's where we want to go with the process of foreclosure legal defense. Are these results achievable? Yes, they are. A recent example, we had a client achieve a better than 50% reduction in the principal balance of their mortgage. It went from $280,000 down to $134,000. It was a brand new 30-year mortgage at 2% interest rate, fixed rate, and all their unpaid payments and taxes were waived. Can you imagine that was a very happy client? Are these results guaranteed? Well, no. No one can legally or ethically guarantee you anything. These results are any results. However, let's take a look at how these results can be achieved. You're about to learn exactly how your rights are being violated or have been violated, and how you've been victimized by the banking system, Wall Street, and the whole mortgage securitization mess. Everything we do is accomplished through the court system. Only through the legal system can the banks be successfully fought, because only in the court system can the playing field be level. Because no longer will you be at the mercy of your bank. As you most likely have already discovered, they don't have any mercy. You're going to have a knowledgeable and capable attorney representing you, fighting for your rights. Before we get into the particulars of the foreclosure legal defense process, let's talk about some common foreclosure solutions that do not work. And there's three basic things that people typically look at: loan modification, bankruptcy, and short sale. Loan modification is by far the most common and most popular option that people try. The problem is that very few loan modifications are actually granted. Statistically, 65% of all loan mod requests are denied. And of the 35% that are granted, 60% of those fail within a few months. And that's typically because they're not true loan mods. We see a lot of instances where people get a loan modification and their payment goes down $20 or $40. Or we've even seen some so-called loan modifications where their payments went up. And that's because they took the arrearage and added it back in. So only 14% of loan modifications are actually successful for the homeowner. And even in those cases, the principal balances are never reduced. So back to our example, if you have a $300,000 mortgage, but your home's only worth $150,000, even if they reduce your interest rate, you're still paying a principal balance of $300,000, which means you can never move, you can never sell your property, etc. Now, the bank often has no intention of granting you a loan mod, and the reason for that is simple. They cannot modify your loan because they don't own it. And we're going to get into some detail about this, but this is, for those of you who have been getting the runaround, this isn't actually why. Because your mortgage company, the bank to which you pay your mortgage or make your payments to, does not actually own your real estate note. And that's why they're always referring to the mysterious investor that they have to check with about your loan modification. They don't give loan modifications because they can't, because they don't own the real estate notes. Well, what about bankruptcy? Bankruptcy is a common thing that people take a look at when they're facing foreclosure. And a bankruptcy can absolutely stop an impending foreclosure. In other words, if you're going to be foreclosed on next week, then you can go file bankruptcy and it will stop that foreclosure. However, bankruptcy does not provide a long-term solution to foreclosure. It only delays the process. There's two types of bankruptcy. The first is a Chapter 7, which is a liquidation. In a liquidation, you're basically surrendering all of your assets to the court other than your exempt assets. The court is to distribute your assets to your creditors according to priority. Well, in your home, it's a secured debt. So because it's a secured debt, you must either reaffirm the debt or surrender the property. To reaffirm the debt, you've got to be current on your payments. If you're behind on your payments, they're going to put you in a Chapter 13. That's a repayment plan. but you have to be able to pay your regular mortgage payment plus a portion of the arrearage, your unpaid payments. So if you're having trouble making your current payment, then how is a Chapter 13 going to help you? Because you're going to have to be able to pay more. They'll let you pay your unpaid mortgage payments typically over a 3 to 5 year period. So most Chapter 13s fail. They fall out. They might last a few months, but typically the people find them unworkable because they're being asked to pay too much. So in virtually all cases, bankruptcy only delays foreclosure. It does not prevent it from happening. What about a short sale? Well, a short sale means that you sell your property for less than you owe, but it requires the approval of the lender or the bank. They have to give permission to accept a lesser amount. And typically, they want to either hold you responsible with a deficiency judgment, meaning that you're liable for the difference between what you owed on the mortgage and what you're selling the property for, or they want to give you a 1099 cancellation of debt. In other words, they want to report the difference between what you owe on the property and what they sell it for to the IRS as though it were taxable income. Go back to our example. Again, a $300,000 mortgage for the home that's worth $150,000. So if you sold your home on a short sale for $150,000 less than you owed with the mortgage, then what they would do is report to the IRS as though you had $150,000 in income. Well, can you imagine the tax liability on that? That's typically not a very good thing for folks. It's not a good solution. And plus, you have to find a new place to live, and you got to move. So generally, a short sale really isn't a good approach or a good solution for a foreclosure. So how does foreclosure legal defense itself work? We're going to look at that, and we're going to look at two aspects of it. There's both a defensive part, which is preventing the foreclosure itself, and there's an offensive part, suing the bank, holding the bank accountable for violations of federal and state law. To understand the defensive part, how we can stop the foreclosure, it goes back to understanding the components of a loan. Now, when you sign a stack full of documents at your loan closing, there's a couple of key documents we want to focus on. First is the promissory note, which is also known as the real estate note. Now, this is your promise to pay a certain amount of money at a certain interest rate over a certain period of time. This is your legal obligation to pay, and it is a negotiable instrument, meaning it can be bought and sold for cash. The other document is your mortgage. The mortgage is not a negotiable instrument, nor is it a legal obligation to pay anything. It is merely a security instrument. The mortgage is the document that pledges your property as collateral for the real estate note. In other words, the mortgage says if you default on the real estate note, then the holder of that note, the real estate note, has the right to foreclose on you and take your property from you. Notice, though, that the right of foreclosure belongs only to the holder of your promissory note or real estate note. That party and that party alone has the right to foreclose based upon a default in the terms of the note. Now, it used to be that the holder of the note and the servicer of the mortgage were the same entity. However, all that changed with the process of securitization beginning in the late 90s, and especially in the period from 2000 to 2010 as the notes and the mortgages became separated. The truth is your note was sold, especially if you refinanced or bought anything in the period from 2000 to 2010 in terms of real estate. So the mortgage company is merely a servicing company. They do not own your note. They do not have the legal right to foreclose on you. The original lender was actually paid in full, and only the holder of your original wedding note has the legal right to foreclose. Well, if the bank you're dealing with, the mortgage company, doesn't have your note, where is your note? Who bought your note? Well, Wall Street bought your note and the notes of millions of other people just like you in order to package them into securities for sale in the secondary market. It was a scheme that made billions and billions of dollars for fat cat Wall Street executives at the expense of the rest of us. And we're going to delve a little deeper into securitization in just a moment. But for now, we want you to understand that your mortgage company, again, is merely a servicing company. They collect your payments. They handle other servicing issues on your mortgage. And the payments that you make are mistakenly called mortgage payments, and we've called them that even in this presentation. But the truth is, the payments you're making are not mortgage payments, because a mortgage has no legal obligation for payment. They're actually payments on your real estate note. They belong to the holder of your note and not your so-called mortgage company. Now, you may have dealt with several mortgage companies, but all that was changing hands as it went from Bank A to Bank B to Bank C is the servicing rights of the mortgage. The mortgage company does not own your real estate note. Therefore, they do not have the legal right to foreclose on you. They can be successfully challenged in court, and the foreclosure stopped because the mortgage company does not have what is known as standing. In other words, they're not the real party in interest. Now, are there exceptions to this? Yes. I mean, if you dealt with a credit union or a small community bank, then most likely they made you a portfolio loan and they actually have your note. If, however, you dealt with a mortgage company or a big lender such as Bank of America, or Chase, or Wells Fargo, Washington Mutual, Countrywide, etc., then your note was sold to Wall Street and securitized, and your lender does not have the legal right of foreclosure. In fact, your lender was actually paid in full, made a nice profit when your note was sold to Wall Street. You don't owe them anything, and it's a legal fraud for them to take your house from you. The right of foreclosure belongs only to the holder of your original note, the one that you actually signed at closing. That document is a negotiable instrument, as we said a moment ago, meaning that it can be bought and sold for cash. Now, a copy of the document is non-negotiable. It's like the difference between a real $100 bill and if I went to the copy machine and made copies of a $100 bill. A real $100 bill you can spend. But if you try and spend a copy, you might end up in jail. So the question arises, if your mortgage company does not own or possess your original note, who does? The truth is, most likely no one actually possesses your original note, or no entity. For the most part, these notes no longer exist. They've been lost or destroyed. While this may seem bizarre, it is a fact. Oftentimes in foreclosure actions, the fact that the original note has been lost or destroyed is fully admitted in the pleadings, because the party filing the foreclosure suit doesn't have the note, can't get the note, but they want to foreclose anyway, without having to prove ownership of the note. So what happened to the notes? You signed the note at closing with your original lender. Where did it go? As we've already discussed, your note was sold to Wall Street and then packaged with other notes for the purposes of selling securities in the secondary market. Now, every time the ownership of a real estate note changes hand, an assignment of the accompanying mortgage is supposed to be recorded in the county recorder of deeds office at a fee paid for that recording. As Wall Street was processing literally millions of these notes and mortgages, recording the assignments properly would take a lot of time and delay the sales into the secondary market, as well as cost a lot of money in fees to be paid to the various county recorder of deeds offices. So they came up with MERS. MERS is the Mortgage Electronic Registration System. MERS was designed to bypass the county recorder of deeds offices and save time and money for the Wall Street boys. MERS was the nominee and then supposedly could assign the notes to whatever trust or entity the note was to be sold to. The problem is that MERS never took possession or ownership of the original notes, and therefore could not legally assign the notes. A number of court rulings have held this to be true. Additionally, there are other problems with the notes in this securitization process. Wall Street bought every real estate note it could get its hands on. Prime notes, subprime notes, the high interest rate notes, and adjustable rate notes, adjustable rate mortgages, mortgages with low initial rates that would later rise to higher, in many cases substantially higher interest rates. Wall Street bought notes that never should have been made and were never intended to be repaid. We ran across a documented case of a strawberry picker in California making $15 an hour, who got a $750,000 mortgage. That's because they were giving out loans with no no documentation, and no income verification. These the so-called liar loans, because nobody cared, because they were making so much money through securitization. Wall Street took these loans. They bundled them by the thousands into large pools of notes called trusts. Trusts were subdivided into tranches or slices. It was a very complex financial instruments designed to make enormous sums of money. The notes themselves were subdivided into these different tranches, with perhaps the interest payments from point A to point B going into one tranche, the interest payments from point B to point C going into a different tranche, and perhaps the principal payments going into an entirely different third tranche, and so forth. Bonds or securities were then sold on these different tranches to institutional investors like private and government pension plan funds. These are the mortgage-backed securities that you've heard about. However, the fundamental nature and character of the real estate notes themselves was changed. The individual notes lost their unique identity. What happened is very similar to taking a group of people and giving each of them an apple. While the apples are very similar to each other, they're still unique and identifiable. However, if you take all the apples, put them into a blender and make applesauce, can anyone identify their unique apple? Of course not. This is very much what happened to these real estate notes. As perhaps you now understand, Wall Street got very, very sloppy in this whole securitization process. It's because they were making so much money. These bonds were sold to institutional investors who were willing to take low returns on a supposedly safe investment. This allowed Wall Street to take a prime mortgage and perhaps double the face value of the mortgage, so that a $300,000 mortgage might be worth $600,000 in bond sales. A subprime or R mortgage might bring in 4, 5, or 6 times the face value, so that a $300,000 mortgage might be worth $1.2 million to $1.8 million in bond sales. Do you see the incredible sums of money these people were making? But that wasn't enough. They decided to commit massive fraud. By all types of people committed massive fraud. The same note would often wind up in multiple trusts. Remember, they were using copies, not originals, so they could put the same one in multiple trusts. There's been at least one case, one note that is, it's been documented to be into 20 different trusts. Now, this fraud allowed Wall Street to actually make anywhere from 20 to 30, perhaps even 40 times the face value of a mortgage. Now we're talking a one $300,000 mortgage might be worth somewhere between $6 million and $12 million in bond sales. It was a house of cards that was designed and destined to crash. And crash it did. Now, when the subprime mortgage crisis hit, the entire economy went into a nosedive. Millions of people lost their jobs. Millions of others suffered drastic income cuts. Real estate values plummeted. And according to the Center for Responsible Lending, American homeowners have lost close to $2 trillion in equity in their homes. Now millions of people can no longer afford their mortgages, but they can't sell their properties either. Yet the banks and the Wall Street firms that caused this mess have been bailed out with trillions of taxpayer dollars. The people bailed them out. But who's bailing out the people? Not the banks, that's for sure. The banks are trying to steal the homes from the people through foreclosure when they don't even own the real estate notes. They're continuing the fraud. The good news is that foreclosure can be stopped. The party bringing the foreclosure action can be forced to prove in court that they have a legal right to foreclose, that they are the real party in interest and the holder in due course of the real estate note. This is most effective in judicial states like Illinois, Indiana, New York, New Jersey, Ohio, Florida, and others where the lender must sue in court to foreclose. In judicial states, the party suing for foreclosure can be forced to produce ownership documents proving the legal right to foreclose before foreclosure can take place. The burden of proof is on them as the plaintiff in the foreclosure action to prove their case. And most of the time, virtually always, they cannot do that. Most people who lose their homes in foreclosure do so because they don't fight the foreclosure. They don't fight it by utilizing a knowledgeable and competent attorney in the area of foreclosure defense. When properly challenged, ownership must be documented and proven before foreclosure is allowed by the court. Some recent court decisions back all of this up. And this is only just a sampling of a number of court decisions that are out there. 2011, just recently, a decision handed down by the 8th Circuit Federal Appeals Court. A foreclosure was reversed because the foreclosing bank was not entitled to receive payments under the note. The bank could not show or prove chain of title. The 5th District Appellate Court in Illinois reversed a foreclosure where the foreclosing entity was merely a servicer of the mortgage and not the owner of the real estate note. 2011 decision from the Eastern District of New York Bankruptcy Court. In this case, the court slammed MERS for acting both as agent and principal in the same transaction and exposed MERS' alleged principal as being unable to produce any evidence of ownership of the real estate note. 2010 case from the Eastern District of California Bankruptcy Court. The court held that neither MERS nor its alleged principal were the real parties in interest because they could not provide any evidence of the whereabouts of, much less any legal title to, the original note. A recent ruling from the Massachusetts Supreme Court calls into question all foreclosures done in Massachusetts over the last 5 years due to improper documentation of ownership. In fact, the Massachusetts Supreme Court ruled that such foreclosures were null and void, and that subsequent purchasers of these illegally foreclosed homes could not have good title to the properties purchased because the foreclosing entities never had good title. The states of New York and New Jersey have recently passed laws that require attorneys filing foreclosures to sign affidavits attesting to the validity of the ownership documents being used to justify the foreclosure action. As a result, foreclosure actions in these states have dropped by 80%. Now, CBS's 60 Minutes recently did an expose on the use of fake, fraudulent, and illegal documents being utilized by these banks in foreclosure lawsuits. Because the original documents no longer exist, the banks have resorted to criminally forging the documents. Watch the 60 Minutes piece. It's posted on our website and it's posted on this page. Fake and fraudulent documents and illegal foreclosures have become such a pervasive problem that the state of Nevada recently enacted a law that makes it a crime, a felony in fact, to utilize fake documents, false documents in a foreclosure proceeding. Way to go, Nevada. Do not let your house be stolen from you. You can fight back. Foreclosure can be stopped. The foreclosing entity has the burden of proof in a judicial state, and they cannot prove their ownership. Now that's the defensive side. Let's talk about the offensive side. The offensive side has to do with conducting a forensic loan audit, what's known as a compliance audit, documenting violations of various federal and state laws committed by the lender. What we do is we do a thorough review of your closing documents because real estate transactions are governed by a number of different kinds of laws. And the tolerances for these laws are very narrow, very strictly define what the lender must do or the things that they cannot do. So the laws that come into play here might be like the Truth in Lending Act, the Real Estate Settlement Procedures Act, the Homeownership Equity Protection Act, Fair Debt Collection Practices Act, as well as State Unfair and Deceptive Practices Act. These are just some of the laws that come into play. So by going through and documenting these violations, these are things that the lender can be held accountable for. And we typically find somewhere between 20 and 30 violations on every audit we do. Now, some of them are technical. I mean, there might be cases of I's not dotted, T's not crossed. But in many cases, it's far more than that. We find understated finance charges. We find hidden fees. We find yield spread previews, undisclosed yield spread previews paid to brokers. We find misrepresentations about the real interest rate. And we even find out and out fraud. Now, depending on what's discovered, there's different remedies. The remedies could be statutory penalties. It could be damages that could be paid to you, actual punitive, exemplary. It could be attorney's fees. And if we find some TILA violations, it'd be a refinance that you did. But under Truth in Lending Act, there's a right of rescission that might come into play. With a right of rescission, you can actually unwind your loan, meaning you could demand all the money you paid all these years back from the lender and give them back the property. Now, it doesn't mean you have to do that, but it's all about gaining leverage. It's even possible through these types of actions to get what's known as quiet title. A quiet title action is an action to remove encumbrances from the property. It's possible to get the property free and clear. Now, that doesn't happen very often. It'd be kind of like winning the lottery if it did, but it is possible. And there have been instances, and we have instances, where that is in the process of actually happening. Well, now do you see why the bank would want to settle? If they cannot foreclose on you, they're unable to produce their proper ownership documents. Now we've asserted different causes of action that they're being held liable for. They could be responsible for damages and penalties and all kinds of things. Well, now you have leverage. Now your loan can be rewritten because it makes sense then. Because the bank would rather have a reduced amount that's a paying loan rather than a higher amount that's a non-paying loan. So the idea is to accomplish the different objectives that we talked about earlier, to give you a mortgage that you can afford and one that actually makes economic sense. Brand new 30-year mortgage, long-term fixed rate, something that reflects the actual market value of the property with an interest rate that makes economic sense. There are two programs, one for people that want to keep their property and one for people that would like to walk away. If you want to keep your property, this program involves the homeowner paying a monthly fee. It's typically around half of the monthly mortgage payment with a minimum of $750 a month payment. And if you're having a hardship, let us know. We'll do what we can to work with you. There's also a one-time setup fee of $500 due with the initial month's payment. Now, the monthly fee covers all legal and administrative costs associated with this process. Now, if you want to walk away, this is designed primarily for people that have investment property, but occasionally we find homeowners that want to walk away. Perhaps they want to move to a different state or something. This program does not require the homeowner to pay a monthly fee. Instead, the homeowner surrenders control of the property so that it can be rented out. Not title to the property. We don't take title at all, but control of the property. The rents fund the litigation. Now, the idea here is to force the bank into a short sale, discounted enough to allow the property to be remarketed for a profit. The homeowner shares in the profit. And there's no out-of-pocket cost for this program. We hope you found our presentation informative and educational. If you'd like more information, if you'd like to get some specifics of how all this applies in your situation, please take these 3 steps. Number 1, watch the 60 minutes video on this page. 2, complete the form below. We need to get some information from you about your situation so that we can talk with you about your situation and how what we can do can apply to you and how we can help you. And we will contact you to arrange for a personal consultation. We'll talk with you, speak with you one-on-one, typically over the phone. If you're in Illinois, you can come into the Downers Grove office, but we want to speak with you individually and see what we can do to assist you. Thank you for watching our presentation, and we look forward to working with you. Thank you.